So we're still one member shy of a quorum, but I think we'll get underway.
Nope, we got a quorum.
We have a quorum. Mr. Cooper, welcome. Let's take roll, please.
Daly,
Here.
Beth Gaines, Travis Allen, Calderon, Cooley, Cooper, Tababne, Frazier,
Here.
Gatto, Gonzalez, Grove,
Yeah.
Mays,
Unlikely to be here.
Rodriguez.
I saw her this morning.
Wow. Okay. Thank you. A quorum is established. This is the April 22nd, 2015 meeting of the Assembly Insurance Committee. Let's take up the consent calendar, which includes item 3 and item 7. There's a motion and second on the consent calendar. Roll call vote, please.
Daly,
Aye.
Daly, aye. Beth Gaines, Travis Allen, Calderon, Cooley, Cooper,
Aye.
Cooper, aye. Tababne, Tababne, aye. Frazier,
Aye.
Frazier, aye. Gatto, Gonzalez, aye. Gonzalez, aye. Grove, Mays,
Aye.
Mays, aye. Rodriguez,
Aye.
Rodriguez, aye.
Great. What was the vote on that, please? 7-0 on that, on the consent calendar. And let me announce that item 4, AB 944 by Obernolte, has been pulled. It's off the calendar. And the remaining bills now, we will move to those. Sign-in order. Who's first, Mr. Sargent? Mr. Nazarian, but has he signed in? So Nazarian's not here, but Mr. Gordon is here. Mr. Gordon, if you're ready, let's go right to your bill.
Good morning again.
Is that working? Go ahead, Rick.
Good morning, Mr. Chairman and colleagues. AB 1406 would create the Bail Investigation and Prosecution Fund by imposing a fee on each bail transaction. As drafted, the bill would impose this fee on surety companies transacting bail in California. The funds collected would be divided between state and local efforts, with 30% of the funds available to city attorneys and district attorneys, and 70% to the Department of Insurance to investigate, enforce, and prosecute illegal bail activity and code violations. The Department's Investigation Division is charged with enforcing applicable provisions of the California Insurance Code, including the investigation of parties involved in the bail industry. The division pursues prosecution of offenders through both regulatory and criminal justice systems. Unfortunately, as you will hear in a moment from the witnesses, in the past 5 years, the seriousness and number of bail complaints has increased. Local prosecutors have not received additional resources to address this increase, while the limited resources of the department has not allowed for a comprehensive bail enforcement program. Creating the Bail Investigation and Prosecution Fund would provide the dedicated resources to investigate bail-related complaints and to prosecute those cases that rise to the level of criminal conduct. It would also better enable the department to regulate and oversee bail products. The fund would also assist city attorneys and county district attorneys in investigating and prosecuting bail cases, which would help improve the state of bail in California for consumers in need of this vital service. The bill would also provide accountability on the funds collected by requiring an accounting on the use of funds, the authority for fiscal audits, and the annual investigation enforcement reports to be posted on the department's website. I have with me a number of witnesses that can speak directly to the issues that have arisen for the need for this measure. And we'll go to my witnesses.
Please, thank you.
Good morning, Mr. Chairman and members. Robert Harrell, Deputy Insurance Commissioner for the Department of Insurance. We are the sponsor of this measure. We don't jump in with legislation in bail very often. Bail is a surety bond, and so that's why we're the regulator that's relevant here. We only jump in when there's a problem that sufficiently needs legislative attention. There is a problem that sufficiently needs legislative attention here. We saw, beginning in 2012, basically a tripling of the kinds of cases that are coming in. And simply put, due to scarce resources, we are not able to get to anything but essentially the tip of the iceberg of these cases. And unfortunately, the problem has gotten bad enough that between us and our local partners in law enforcement, all of whom are in support of the bill and you're going to hear from in a moment, we need to step in. So that's why this proposal is on the table. We want to thank Assemblymember Gordon for carrying it. We want to thank the chairman and his staff for working diligently with us on this issue. With that, I'll turn it over to Eric Hubner, who's from the department's enforcement unit and has years and years of expertise in just this area. Thank you.
Okay.
Good morning. Thank you for the opportunity to address the committee. Complaints, as Robert indicated, have steadily increased in the past 5 years in volume and significance. The emergence of gang and criminal organizations involved in illegal bail activity and the sophistication of illegal bail activity currently encountered by our investigators does warrant an aggressive prevention, investigation, and prosecution program dedicated to eliminating these schemes and practices. The types of allegations in scheme include the use of inmates as bail solicitors, premium theft, theft of collateral, civil rights violations, assault, illegal bail fugitive recovery tactics, fraudulent motions in the filing of forfeiture motions with county council, guerrilla marketing and deceptive sales and solicitation tactics, the use of unauthorized badges and safety gear intended to provide an appearance of law enforcement amongst the public, and spoofing or redirection of law enforcement website searches conducted by the public to obtain information on an inmate. The new program would provide essential funding to investigate, enforce, and prosecute illegal bail activity and code violations. We're also talking administratively because there's a licensee involved. The proposal would also provide outreach to the public, law enforcement, the courts, surety companies, bail agents, solicitors, and permittees.
Is there a second? There's a motion and second. Please continue with your...
And just in summary, local law enforcement, the court system, county council, they do not have the resources sufficient to adequately investigate these scams. This bill would provide a measure of public integrity in how bail operates in California.
Other witnesses in support?
Very briefly, good morning, ladies and gentlemen. My name is Scott Tsui. I'm Assistant District Attorney from the County of Santa Clara. We're here to support the bill on behalf of District Attorney Jeff Rosen. As prosecutors, we experience some of the problems that was described in the front line in our county, and we believe talking to our other prosecutors in various parts of the state in various counties in terms of the illegal bail practices that's occurring in the criminal justice system. So we're seeking your support in this bill.
Thank you. Other witnesses in support?
Investigator Bob Taft. I'm with the Orange County Sheriff's Department, and thank you for giving me the opportunity to speak here. I first got started in bail investigations in 2009. The local bail association actually filed a lawsuit against the department saying there were a number of allegations occurring in our facility that we as an agency were not addressing. And this actually falls under the Department of Insurance, but the department was named in this lawsuit. And over the course of the 5 years of doing this investigation, I am a proponent for bail. It is a necessary component within the criminal justice system. However, there are significant issues. The crux of this lawsuit had to do with inmates being strong-armed to use a particular bail company and staff involvement in referring information to bail companies. My investigation, I didn't substantiate any of that. However, I did uncover pretty much everything that Mr. Hubner was talking about as far as capping, paying inmates for information, unlawful solicitations, questionable surrenders. One of my early investigations in 2010, I identified 27 inmates in our Central Men's Jail that would be referring information to a particular bail agent. Over the course of 3 or 4 months, this particular company made or wrote several $1 million worth of bail out of Orange County Jail, to the point where it got so good that the bail agent and her unlicensed solicitor actually broke off and started their own company because they were making so much money. In 1 month time frame, they wrote $1.3 million in bail out of Orange County Jail, all based on this illegal activity. I've come across surrender issues. Actually, one case that was referred to me from the Department of Insurance, young lady was arrested. She offered her car as collateral for bail. She owed the agency $3,000. Bail agent actually used her car for personal purposes while she was in custody, racked up about 5,000 miles, got several tickets on the car, and eventually sold it for $24,000, and she never received a dime.
Sir, what's the status of the prosecution on that case?
Locally, on that
No, you're not the
particular-
prosecutor,
Oh,
but I'm
sorry.
just, do you know the status?
Because I don't work for Orange County.
Yes, sir.
Okay.
This occurred in Orange County.
You'll be a witness, you'll be involved in the prosecution, supplying the evidence and so forth, right? Has it been prosecuted yet?
From Orange County District Attorney, that
Right.
case was refused.
Okay.
It was subsequently administratively turned over to the Department of Insurance to look at.
Okay.
It's pending administrative action.
Gotcha. Thank you.
And there
Thank
are
you.
ongoing
Okay.
investigations.
That's okay. Other witnesses in support, please?
Mr. Chairman, members, Randy Perry with Aaron Reed and Associates on behalf of PORAC in support.
Thank you.
Sean Hoffman with the California District Attorneys Association, also in support.
Mr. Chairman, my name is Akili Nixon. I'm with the law firm of Isaacs, Friedberg, and Labaton. Before that, I was a prosecutor in Los Angeles for 10 years, dedicated solely to the investigation and enforcement of bail bonds issues. In Los Angeles, when we started about 10 years ago, we had to do something because the status quo was unmitigated chaos. There were assaults, batteries, serious crimes happening on the steps of the 77th Division Police Station, happening by the employees of bail bonds companies. They had actually employed, there's no other way to say it other than thieves, criminals, and crooks were working for bail bonds companies. I personally prosecuted and convicted probably a dozen employees of bail bonds companies. And as I went around the state talking to other agencies, prosecutors, and investigators, I found out the problem was simple. There simply weren't enough police officers to dedicate to invest this stuff, and they didn't have the expertise. They really weren't experts in the insurance code. The Department of Insurance, they're the experts.
All right. Thank you very much, sir. Thank you. Other witnesses in support of the measure?
Tony Suggs, Castle Bail Bonds from Richmond, California. I support it also. I'm a single office mom and pop. My wife and I own the business, and our business is directly affected by the unethical and illegal activities of the other bail agencies. They're pulling in way more bail than we are simply because of their tactics that they're using. Thank you.
Thank you, sir.
Good morning. My name is Jerry Campana. I'm owner of a bail bond company in San Francisco, San Mateo County for 31 years. I'm a licensed bail agent, and I'm a former board member of 10 years with the California Bail Agents Association. AB 1406 funding is the very element that we need to provide resources to clean up our industry and save the ethical mom and pop businesses, protect public safety, protect against consumer fraud. And as an owner of a mom and pop, I respectfully request an aye vote as my support. I thank you very much.
Thank you. Are there any other witnesses in support of this measure? If not, are there any witnesses opposed to the measure? I see some people moving forward. You can use the mic right there if you'd like. And meanwhile, if you folks are free to depart.
And then the rest.
You're welcome to use either mic, either the stand-up mic there or come to the table, whichever is most efficient. You're welcome. These are witnesses in opposition to the measure. Go ahead, sir.
That's correct. Thank you. Thank you very much to the committee. My name is Topo Padilla. I'm a licensed bail agent for 32 years. I own and operate a business here in Sacramento, California. I am a member of the Golden State Bail Agents Association, and I'm on the board of directors for the Professional Bail Agents of the United States. So I represent a good number of bail agents. There's 3,200 bail agents in this state, approximately. I take great offense at the big net that is thrown over the good men and women of this industry. There are a few bad actors. The problem that we have in this state, and we are trying to work with the people on the other side of this, and the good friends of mine from the Department of Insurance, I want to help them do one thing, and that is put up the law, clean up the laws in Title 10. They are so ambiguous, they're in conflict. They have not been amended and fixed since 1977. This is like having a small town of 3,200 people and no speed limit signs, or speed limit signs that change from stop sign to stop sign. We need to fix that first, and that's what we want to do, and we've tried to work with the author. We want to work on Title 10. We would love to see this be focused on Title X, give the good men and women of the Department of Insurance the laws and the ability to go get convictions. Recently, there was a case that they've investigated for over 5 years in Stanislaus County, a 5-month jury trial. They lost. It was a tragedy. Millions of dollars were spent going after a man. They lost that case. And the reason they lost that case is because of the conflicts in laws. We in the bail industry are not saying, no, there's not any bad actors, but the fact of the matter is this: we want the laws to be more clear and concise, and we feel that will do what everybody in this room would like to have.
Thank you, sir. Other witnesses against the measure?
Hi, good morning. My name is Corinne Rankin. I'm a bail agent. I'm a board member for the California Bail Agents Association. My father started our family business in San Mateo County in 1968, and we've been there ever since. CBAA represents the majority of bail agents in California who are small business owners, taxpayers, and job creators. Our position is we want to help the Department of Insurance to succeed in their goal. Unfortunately, the insurance code and the laws that regulate bail agents are not designed for this bill to succeed. This bill is essentially putting the cart before the horse. The laws and the regulations need to be cleaned up. They need to be tightened up before any prosecution can take place. We know Investigator Taft, and he has had an unsurpassed amount of unfortunate and the inability to prosecute. You asked him questions here today, and the prosecution is at a standstill. And that's solely because the laws are not designed to criminally prosecute bail agents. The laws are designed for the Department of Insurance to regulate licensees. I'm horrified by what I've heard today, the accusations against bail agents. If this is true and these bail agents have done this, then the Department of Insurance needs to revoke their license, plain and simple.
All right, other witnesses in opposition to the bill? Sir, you're next.
Mr. Chairman, my name is Randy Parton. I'm the Senior Vice President of Lexington National Insurance Corporation. Lexington National is a member of the American Bail Coalition, which is a national association of surety bail underwriters. And the American Bail Coalition opposes this bill. The reasons for that is, while we feel that the Commissioner should have the resources and the authority and the staff to regulate these matters, we don't think that this bill sufficiently addresses that. You would be imposing essentially a 40% surcharge on all bail bond premiums in this state. You would be increasing the surety company's financial responsibility by 40% over the $8 million that we're paying right now. There is uncertainty in many of the elements of the bill. It's missing integral pieces. Merely levying a fee doesn't promote the goals or accomplish the goals, which are to remove those few bad actors who exist within the bail bond community. We would like for the Commissioner to have the authority to appoint a committee of stakeholders to have a more pragmatic, more deliberate investigation and review of the problem and make those recommendations before the legislature so that we can create viable solutions and develop a symbiotic relationship between all of the stakeholders within the criminal justice community. Again, while we support the intent, we don't think that this bill addresses those concerns or will achieve those goals. I urge you to vote no, and thank you for the opportunity to address you.
Thank you, sir. There are other witnesses in opposition. Please go ahead.
Good morning. My name is Maggie Crines. I'm from Long Beach. I've been a licensed agent since 1988. I am the current president of the California Bail Agents Association, which vehemently oppose this bill as written. I also am employed by Accredited Surety and Casualty, which represents a network of small businesses, and as such, Accredited also opposes this bill.
Thank you.
Good morning. My name is Gloria Mitchell. I am a small business owner in Pomona, California. 25 years in this industry, second generation with daughters that are third generation. I take pride in being able to stand before you as a professional and involved in my community and would support anything that could correct the things that are going on. But I oppose this bill as written. Thank you so much.
Thank you.
Greg Padilla from Greg Padilla Bail Bonds. I've been a licensed bail agent for 36 years. I have sit here and watched the Department of Insurance gather our money, and we've been beat up for 36 years. And it, you know, it's going to be fixed tomorrow. In a perfect world, it might be. This might work. But all we're doing is gathering money for retirement, and it's just not going to work. I am opposed.
Thank you, sir.
My name is Brandon Padilla. I'm a licensed bail agent in the state of California, and I'm opposed.
Thank you.
Sylvia Solis-Shaw on behalf of Los Angeles City Attorney Mike Fiore. I'm actually here in support of the bill. I apologize for my tardiness. Thank you.
Well, good. Thank you very much. Any other witnesses? If not, go to after we deal with some of the amendments that have been suggested, we'll go to member questions and comments. The staff report, comment number 5, suggests a lower fee, which would be $15. And there's a second amendment which deals with the hearing process in the insurance department, which I don't think is a controversial amendment at all. Mr. Gordon, are you okay with those two amendments, the $15 fee, basically the committee amendments? Are you okay?
To move the bill, we'd accept the committee amendments.
Great. Thank you. That'll be the chair's recommendation. Are there questions or comments from members? Mr. Mays.
Yeah, that's interesting that we would go from 30 to 15 because if we're talking about a fee, then the question should be is we need enough people to be able to do the enforcement. In the committee analysis, at the $30, the estimate was $5.2 million in added revenue to the department, which 30% of that then would go to the local district attorneys for their enforcement. So the question is even at the $30, how many people were you expecting to hire to be able to do the enforcement? What was this revenue going to be used for? And how did we come up with the $30 fee? And if we're going to go to a $15 fee, then would you split it in half?
Assemblymember Mays, thank you for the question. Yeah, you're generally at $30, it was going to bring in about 5. Now, there has been a slightly downward trend in the number of bail bonds sold from, say, 2011, 12, 13. There's some factors that go into that. Some counties have been releasing more people on their own recognizance. Also, Prop 47 plays a role because that's essentially made the sort of bail pie a little smaller, which concerns us in law enforcement because we think it acts to exacerbate some of the bad behavior that's occurring. I want to be clear. We're not saying that all bail agents are doing this. We're not. However, you've got a pretty limited universe. We've got other similar kinds of funds that deal with, for example, auto insurance fraud and other frauds. And there you're talking about millions of auto insurance policies sold. So you can have sufficient funds to help us and local law enforcement with 30 cents or $1 in life and annuity. This is different because you've got a smaller universe of bail bonds and a smaller universe of licensees. If the fee were to be decreased to $15, the commissioner told me that he'd like obviously the fee to be as high as possible in the sense we opened at 30 in the sense that allows us to A, work up more cases, and B, work with more counties and their district attorneys to prosecute more cases. We work up the cases generally, they prosecute the cases. So you are halving. Essentially, we did some kind of back-of-the-envelope calculations based on a halving of the amount. And what you're doing is instead of allowing 7 or 8 counties to get grants, which they're competitively awarded. We audit on the back end. It's dedicated only to these purposes. You're going to instead be looking at 3 to 4 counties. So I understand and appreciate and respect the committee amendment. We've worked very closely with the committee staff and the chairman on this. But that's the context.
But now this is a fee, not a tax.
It is a fee.
So isn't there some sort of a nexus study that's been completed on why the $30 is the amount that's needed?
Yeah. because it's essentially when you look at the complaint data and you see 2011, 82 complaints and cases, 2012, 225 complaints and cases. That's a tripling, basically. And it's 2013, 230 complaints and cases, 2014, 227. That's the problem. That's why we're here before you today.
And so based on that Nexus study, how many more employees are needed to do that enforcement?
It would be a combination. I don't have a final number, but it would be a combination of some people in the legal side who support the enforcement unit, and then also literally investigators who would do nothing but this. Let's just do the math at 15. At 15, you're bringing in about $2.5 million, 30% of which would go to the local DAs. That's about $750,000. Again, ballpark figures. That would leave the remainder with the department. We could hire some people to do that, probably 5 or 6 enforcement and legal people to be able to work more of these cases up. However, the concern that's been raised by the commissioner to me personally and also by our enforcement folks and the local DAs is that I used the phrase the tip of the iceberg in my opening comments, and that therein lies the rub. So we appreciate all the work that's gone into this, and I just wanted to give you the context to answer your question.
Do we have a copy of that Nexus study? Can that be provided to us?
I can get you some information about, at certain amounts, how many people we could bring in. Absolutely. I can get you that information.
All right. Are there other questions? Mr. Rodriguez.
Yes, I want to thank the authors for bringing this bill forward. And I just wanted to see if you and the Department of Insurance will be able to work with some of the opposition on some of their issues and concerns they're bringing forward.
I plan to address that in my close.
Thank you very much.
Other questions or comments by committee members? All right. Ms. Gaines, did you have a question?
Let me just jump in if I...
Mr. Cooley, please do.
The one issue that I see in this is the bail system is sort of an adjunct to the court. It interacts with the courts. I know in other states where they have gone into the bail arena and tried to work it out, this common of stakeholders resonates with me. I know other states, they've brought in representatives from the court system, the surety companies themselves, of course, law enforcement, sheriffs, police, bail agents. I know when you look at the program of the dollar surcharge to support fraud-related activity in the auto insurance area, that grew out of a lot of prior work which documented the scale of the problem. It was actually front-page news all around California, sort of the fraud issue that they're trying to tackle. I sort of feel, I understand bringing the issue forward, but we're hearing the argument that the regulations, the statutes, the insurance code, the penal code, that these are not in sync. The insurance commissioner does have a function in this area, but there's a lot of other players. And as I note, in other jurisdictions, it seems there has been more of a collaboration on the front end to bring forward recommendations. And I just think to do our work decently and in order, that would be very beneficial. And I know in the auto insurance area, when we established that, that's what was done. So that's a concern I have sort of going forward. I think it's not the best methodology that is bringing this policy here because there's other stakeholders who are not in the conversation.
Thank you, Mr. Cooley, and I think that's well said. There's a lot of other context here behind this. Mr. Cooper.
Thank you, Mr. Chair. Yeah, just for the Department of Insurance, I would like to have seen you guys reach out to the industry and work and collaborate on this. These problems have been going on for years as far as I ran the downtown jail for 2 years as a commander, and people were always complaining about someone getting up, getting more in bail money and inmates, and that stuff does go on, but it's gone on for years, and it's really hard to enforce. So, you know, do I support more regulation? Absolutely, but I think we've got to bring the folks together and work on something. But I think it's much needed. I support your bill, Mr. Gordon, but I think we need some tweaks, and I would have liked to have seen DOI reach out earlier and work with these folks. They're willing to work. I've talked with them, and like I said, these things have been going on for years, and rarely do you see cases prosecuted. I mean, maybe in L.A., but for the most part, as far as I'm concerned, as far as I'm aware, there's not a lot of prosecution, and it is much needed. But I would like to see more done on the front end initially.
If I might, Mr. Chairman, just on both Mr. Assemblymember Cooley and Assemblymember Cooper's comments, we have historically had, I've been with the department 2 years now, but there's historically been, there are folks in the department who work part-time on these cases because we don't have the resources to dedicate more to it, that definitely have established relationships with the bail industry. So I just want to clarify the suggestion that there's some sort of, that there's not communication that goes on. There is communication that goes on. We have, from the first moment we, for example, began talking about this bill, we said we are open to suggestions about clarification of Title X. I've got a laundry list of court cases where Title X, the statute itself and all the regs behind it, we win pretty much every time we go into court in terms of the authority and how they work. That doesn't mean you're going to win every single court case. In the Stanislaus County case that was raised earlier by the opponents, I should note that, A, we didn't prosecute that case. Obviously, the local DA's office did. But the office manager in that situation pled guilty to theft of more than $400,000 in funds. So you don't win every jury trial, as you well know, given your background. But we have been willing to collaborate and communicate with all parties, and that is unchanged.
So are most cases prosecuted by DOI or by local jurisdictions?
We don't prosecute. That's why the local DA component of this bill is so very important,
right.
Because they prosecute those cases. And those are partnerships that are very important to us.
But as far as investigations go, in comparison, what percentage does DOI initiate or investigate versus the local jurisdictions?
We tend to do more of them. That really varies county by county. It's a resource allocation question. It's a priority of the DA's office question as well. I would just note that in compared to some of the other kinds of fraud cases that we see, some member Cooley talked about auto insurance fraud, these cases are fundamentally different in a couple of ways. One, usually when we work with insurers, they have their own internal fraud staff. They'll give us a lead or a tip or maybe a case that's completely worked up or partially worked up. We help put that together, then it gets prosecuted. With these bail cases, we're essentially almost always starting from ground zero, which means they're longer and more comprehensive and more expensive to work up. And that's part of the problem. It begets itself. There's scarce resources. Not all DAs really fully understand in their offices this area of the law. It's not a priority. And so then it becomes something where what you heard from the gentleman from Los Angeles, who was a prosecutor for a decade, essentially what he said is there's no cop on the beat here. And that therein lies the rub. We think that with these resources, we can help get to more of those cases. Our hope then is that that has an important deterrent effect that, the department and the local prosecutors are paying attention more to these kinds of cases with these resources, that we hope that that has some impact.
Thank you.
Thanks.
All right. Thank you. Mr. Gordon, you have an opportunity to wrap up and make any closing comments.
Thank you, Mr. Chair and committee members. Appreciate the robust discussion. I think bail is a very important tool in our criminal justice system, and it is one that has worked well for many years. And undoubtedly, the vast majority of folks who are in the industry are upright, professional, and are not involved in criminal activity or in scams. In any profession, there's always a small minority who pushes the envelope, violates the rules. This bill is not about the vast majority of bail bonds folks. It's about the very small minority. I had the opportunity just in the last couple of days in meeting with representatives of the industry to be made aware of their concerns about this gap from their perception between the Title X regulations and law. And I am committed to trying to work with them and with the department to resolve that problem because I think that that would be helpful in the bail process. So when I took this on, I thought, this looked like kind of a simple bill. And here I am realizing that if this moves forward today, I've got a lot more work to do because I think there is an opportunity, and we ought to take the opportunity to try to fix this system and to make sure that we align regulation and law, that we get appropriate tools for the Department of Insurance to use, and we get appropriate enforcement capacity for our district attorneys at the local level. And with that, I would ask for an aye vote. And to clarify, that is a request for an aye vote as amended.
As amended. Thank you, Mr. Gordon, and beautifully said. Thank you very much. Ms. Gaines has a question.
I just have a question for the opposition, if they could come back up. Someone from the opposition, please. Thank you. Going from the $30 to the $15, does that remove your opposition from your industry?
Not at all. It's a great question. We're putting the cart before the horse. We're putting the cops out on the streets without the laws being defined. And when I say the laws are not defined, I've been a bail agent for 32 years. I've worked very closely with the Department of Insurance, and the laws are in conflict in so many areas, and we want them fixed. We want the speed limits out there. So with all due respect, no, that just does not do it. Let's fix Title 10 today with this bill, and then we'll talk about a fee or funding later. We'll be more than happy to do that later. But let's fix the laws first.
Okay, thanks so much.
Mr. DeBobne had a follow-up, and then Mr. Cooper.
Can the gentleman that just spoke come back up? Can you just give us one concrete example of two laws that are running contrary to each other? Can you give us something that we can tangibly look at and say these are in conflict?
I completely appreciate that question. Currently, if I bail somebody out of jail and I do it on credit and I extend them credit, with our bail schedules being so high today, a good 80% of the bonds we do are on credit. If I extend them credit and they fail to make payments to me on that bond, I, pursuant to one law, can go out and arrest them, put them in handcuffs, and as would happen in Stanislaus County, take them back to my office and sweat them for the money. And there's no definition of how long I can do that. And then I can put them back in jail. However, there's another part of the law that says I can't do that. That is one of the greatest conflicts that we see, and that's the Insurance Code, Title 10, and the Penal Code, Section 1300. We want that fixed. I don't think I should be able to do that. So I hope that answers that question. That is the greatest fix we can make.
And Mr. Cooper had a question.
That was one. He said two. Two examples.
I thought you said one.
I thought he said two.
Mr. Cooper?
Well, you know, Mr. Gordon's an honorable man. He says he's willing to work with you guys on some language to try and address some of these issues. So, yes. Are you good with that?
You know, with all due respect, Mr. Cooper, I am. I know how this works, and we can leave here saying we will. And again, what I am looking at and what we are looking at is this. And we have worked with these folks to look at fixing Title 10. We have to put the speed limit signs out. I mean, yes, it moves this thing forward. We have to put the speed limit signs out. So, I mean, maybe this could be tabled or made something that we could look at fixing that before it moves forward.
Well, it sounds like the votes may be here, or may not. Who knows? But I'm saying, are you willing to work with Mr. Gordon? He's willing to try and rectify this.
If I may, I will remind you of one thing we have been asking for, and I've worked with Mr. Harrell and the people in his office and Commissioner Jones. In the past, we had an ad hoc advisory committee. That committee would get together, we would work these things out, and this hearing would have been about a minute long. We have asked for that, and we would love to see that. If that could be made part of this, that would help matters out extensively.
Do you have anything else, Mr. Cooper? Okay, it's time to vote. The author is closed. There's a motion and second on the floor. Roll call vote, please. This includes the amendments.
Daly?
Aye.
Daly, aye. Beth Gaines? No. Beth Gaines, no. Travis Allen? Calderon? Aye. Calderon, aye. Cooley?
Aye.
Cooley, aye. Cooper? DeBobne? Aye. DeBobne, aye. Frazier? Aye. Frazier, aye. Gatto? Gatto, aye. Gonzalez? Grove? Mays?
No.
Mays, no. Rodriguez? Aye. Rodriguez, aye. 7.
It has 7 votes. The bill moves forward. Thank you, Mr. Gordon, and all the participants. Ms. Gaines has another commitment, and she'll be back shortly. Thank you. And next up is Mr. Nazarian. Is it Mr. Nazarian? Is he next in line? Great. Great. Okay. I thought I heard that. Welcome.
Thank you, Mr. Chair.